President Trump's Gold Card visa program claims to offer a fast track to United States permanent residency for foreign nationals willing to pay $1 million or $2 million through a corporate sponsor to the federal government. Framed as a way to attract top talent and investors, the program treats a large cash gift as proof of eligibility under existing employment-based visa categories. That framing does not withstand constitutional scrutiny. The Gold Card program is not merely aggressive immigration policy, it is unconstitutional. It usurps Congress's exclusive authority over immigration, violates core separation of powers principles, and attempts to raise and allocate federal funds without legislative approval. Whatever its political appeal, the program cannot be reconciled with the Constitution's structure. Immigration law belongs to Congress. The Constitution assigns immigration lawmaking to Congress, not the President. For over a century, the Supreme Court has held that Congress possesses plenary authority to determine which non-citizens may enter or remain in the United States and under what conditions. Congress exercised that authority by enacting the Immigration and Nationality Act, or INA, which carefully defines visa categories, eligibility standards, and numerical limits. The Gold Card fits nowhere in that statutory framework. Congress has never authorized permanent residency in exchange for a direct payment to the government. Where Congress has allowed investment-based immigration, most notably the EB-5 visa, it imposed strict conditions. Capital must be placed at risk, invested in a commercial enterprise, and used to create United States jobs. The Gold Card discards those requirements entirely, substituting a lump sum payment for the statutory bargain Congress enacted. That substitution is not interpretation, it is legislation. The administration tries to justify the Gold Card by routing applicants through existing employment-based categories such as EB-1 and EB-2, and directs agencies to treat the cash payment as evidence of extraordinary ability or national interest. But that maneuver collapses on inspection. Congress actually defined EB-1 visas for individuals with sustained national or international acclaim, and it defined EB-2 visas for people whose own expertise and labor advance the national interest. A financial payment, standing alone, just satisfies neither definition. Treating wealth as a substitute for merit instructs executive agencies to disregard statutory criteria Congress deliberately imposed. The Supreme Court has squarely rejected such shortcuts. In INS versus Chadha, the court held that immigration decisions carrying the force of law must be made through constitutionally prescribed legislative procedures. If a single chamber of Congress cannot alter immigration outcomes unilaterally, the President acting alone certainly cannot. Executive orders may execute the law, they may not rewrite it. The Gold Card is not a minor administrative adjustment. It creates a new immigration pathway, reshuffles priorities Congress set, and implicates billions of dollars. Under the Supreme Court's separation of powers jurisprudence, decisions of this magnitude require clear congressional authorization. None exists. No provision of the INA authorizes the executive branch to sell permanent residency, waive statutory eligibility standards, or replace job creation with a cash payment. Allowing the President to do so by executive order would collapse the distinction between executing the law and making it, precisely what the Constitution forbids. The program is constitutionally defective for an additional reason: it raises and directs federal funds without congressional approval. The Gold Card requires applicants to pay enormous sums, which are euphemistically labeled as gifts, as a condition of receiving a government benefit. Form cannot obscure substance. These payments function as fees or taxes imposed by executive decree. The Constitution assigns taxing and spending authority exclusively to Congress. Congress has set immigration fees by statute and determined how such funds are handled. The President, frankly, has no authority to impose a 7-figure charge and earmark the proceeds for executive-controlled use. This is an end run around the Appropriations Clause and a direct assault on Congress's power of the purse. The gold card also makes wealth the decisive criterion for immigration eligibility. While Congress has sometimes considered financial self-sufficiency in immigration law, it has never authorized the executive branch to sell lawful permanent residents outright. That value judgment, favoring money over family ties, labor, or humanitarian need, belongs to Congress alone. Imposed by executive order, it highlights the program's core constitutional flaw. The President is making fundamental policy choices the Constitution assigns to the legislature. The Gold Card program violates the Constitution's basic structure. It creates a new immigration pathway by executive order, substitutes money for statutory eligibility, raises and directs public funds without congressional approval, and concentrates legislative power in the hands of the President. In doing so, it collapses the constitutional divide between making the law and executing it. But the most telling point is this: there is a lawful path to accomplish what the Gold Card purports to do. Congress has the power to pass private immigration bills, narrow laws granting legal status to specific individuals. These are rarely used, but they remain a valid, deliberate, and constitutional tool. If the political branches truly wanted to admit wealthy individuals based on exceptional financial contributions, they could do so one case at a time, through legislation that withstands democratic scrutiny. But the most telling point is this: there is a lawful path to accomplish what the Gold Card purports to do. Congress has the power to pass private immigration bills, narrow laws granting legal status to specific individuals. These are rarely used, but they remain a valid, deliberate, and constitutional tool. If the political branches truly wanted to admit wealthy individuals based on exceptional financial contributions, they could do so one case at a time, through legislation that withstands democratic scrutiny. Immigration law, however politically charged, is not exempt from constitutional limits. If the United States is to adopt a paid pathway to permanent residency, it must do so through legislation, passed by Congress and signed by the President. Until then, the Gold Card is not reform. It is executive lawmaking by fiat. For that reason, the program is not merely controversial. It is flagrantly unconstitutional.